But it's important, I think, that we tie this up and that we recognise the great discussions we've had and the detailed discussions we've had all day, and that's my job, actually, to try and kind of summarise what we've done, but actually draw out some of the key themes of today. And I've brought out about 4 themes, I think. Actually, power is not the main theme that I think is the main theme we were talking about. It's not a distinct theme, and we got to that point in the last session. We were really talking about power in a very, very clear way. And up until that point, I think, the kind of broadest discussion we had about power was a series of contributions and points that were made about the kind of global and the pre-existing context beyond TTIP. So I guess that's my first theme. A lot of people were keen to talk about how TTIP either replicates things that have already happened or at least duplicates some principles that are already in existence, or indeed that they will have a much broader effect and a much wider effect than we think. Fabio was talking about the general context of bilateral trade treaties, and I think very importantly identifying the point that several of those treaties he talked specifically about Australia and South Africa are in the process of being abandoned or have been abandoned because they haven't worked, and I think that's very important context. We had a discussion in various forms about the kind of the colonial context. And that discussion of the colonial context, I think, was very clearly articulated by Martina, and she said, look, we need to think about the discussions that are being had around outside the US and the EU in the context of the post-colonial situation. Actually, Nikos made precisely that point very powerfully when he identified the Vietnam, EU-Vietnam treaty, and actually, I think, very validly asked people in this room why there hadn't been a social movement. I happen to think it's not anyone's fault. But it is a valid question about why there hasn't been a social movement in Europe, and why this has been largely, again, something which has been under the radar. We can talk about the reasons for that. Also, Nick's point that half of the world is actually covered. Stop me if I'm misquoting, but I think Nick said that half of the world is covered by half of the world's nations are covered by very, very similar treaties. So therefore, this is something that we have to see as part of a process that goes way beyond TTIP. And then we kind of drilled down into various discussions about this global context, and Keith Ewing's point, actually, that when participants go into those treaty negotiations, when parties go into those treaty negotiations, very often we think that the centre of the negotiations is the treaty itself. And he very, I think, clearly reminded us that actually there's no prospect for raising labour standards as part of a bilateral treaty, because those standards aren't observed in the first place. Those ILO standards that he was identifying. Although, and he very persuasively and powerfully argued, a context that we don't really understand in this country, and that's the context of collective bargaining. There is still a collective bargaining culture, similar to the one that we had previously up until the 80s, till it began to be deconstructed in the 80s, in many European countries. And one of the potential effects of TTIP that Keith argued would be for the US to establish a system of trade union and industrial relations in Europe that currently exists in the US, and actually will compromise those collective bargaining agreements. So I think the kind of broader points that Paul made, the context of the long history of capitalism, and that TTIP is only one stage, and I actually think that's where we got to the kind of core of in the last session. It's a long stage in actually probably, I know there's big debates about this, but the tendency of the rate of profit to fall, right? But at least it's about reclawing some kind of earnings, and at one level, this is about profit accumulation, and about locking in, as Paul said. Tina, there is no alternative about locking that in to the global advance of capitalism, even further so that it can't be opposed. So those are all issues around the global context, which were either pre-existing or will exist long after TTIP collapses or goes ahead, or whatever that might be. And I think there's an important point in all of this, which is that that's been made in several of the sessions, the be-all and end-all is not TTIP. And Nick made this point at the end, if TTIP does go, then it's really only a starting point to think about how we reshape social relationships. And that brings me neatly to my second theme, which is a number of speakers have identified where TTIP potentially does reshape social relationships. And I'm going to identify, I think, 6 of those. Sorry, I'll try and speed up. We've talked about too much today. Okay. Look, it deepens the concept of property and the legal category of property in relations between nations in politics. That's very clear. Again, Nick Dearden was very clear to talk about the way in which the expropriation of particular assets becomes formalised in some of those arbitration processes. And what happens there is that a concept of property becomes real within that process that maybe not was real before, because largely we may be talking about future earnings, right? Things that have not yet materialised. So the materialisation of future earnings or future profits means that concept of property is being reconstituted, perhaps in fora such as the ISDS. Secondly, Robert Howe's very clearly articulated what a lot of people have been concerned about in relation to the NHS, and that's the reshaping of public services, which of course reshapes the relationship that we have with local governments and with national governments. The team very clearly articulate how those trade agreements also reconfigure and reconstitute domestic relations of production. Her key example was agriculture, and she used the example of Ireland, but especially in a context in which big producers can be set against small producers. And of course that was one of Paul's points, I think. No, sorry, it was Nikos's point about thinking about small businesses and representing small businesses in all of this. And perhaps something we forgot in that discussion was actually the way in which this is not just about businesses confronting the state, it's also about businesses confronting other businesses and about a trend towards monopolisation. It also reconstitutes social relations. Of course, and I've made this point, we need to kind of think about the post-colonial situation and how relationships are being reconstituted in colonial terms, but I think I've said enough about that under the first theme. This is about a kind of reconfiguration of rights as well, and I know Michelle wants to raise this issue in the sense that the corporate rights are being, the rights of the corporate person are being pitted against the rights of the real person, the real human person. So there is a kind of artificial relationship between the corporate person and real human aspirations that we also have to think about here. And I think Paul actually was the only person to raise the issue of the legal and political structure of the corporation as being reasserted at the centre of this in a structural way. I know that's kind of what we were all probably talking about. And that brings us to that human rights point, which I think Barnali really powerfully kind of identified in relation to some of the cases that she talked about, not least the beef hormones breast cancer case. But I'll kind of recall her words. Actually, rights to health and gender equality can only be guaranteed by removing the ISDS clause, and I think that was she illustrated that very powerfully. I'm going to come back to whether there might be broader issues around rights, and I'm sure Michelle will as well. So the third theme is just about how this, in a political sense, undermines democratic accountability, how the potential for TTIP is to undermine democratic accountability. So reversing democratic decisions that have been made, and Robert Howe's talked about the way in which arbitration had been imposed around the Argentinian government bonds case after the Argentinian crisis, and led to the sequestration of the Argentinian ship, as he noted. But specifically noted the rise of a litigation industry, so a litigation finance industry, which now pulls the levers and very often selectively chooses or engages in fishing expeditions in order to as he put it, reverse those democratic decisions. And even when those decisions are damaging to human health, of course, and we know that's Gabriel's point very clearly, a whole series of cases where he argued that the US had tried to very directly lobby the European Commission not to ban the chemicals that kills. I think he actually said this is the blueprint for TTIP. I mean, Paul, I think, made a really important point actually in the last session where he said, look, it used to be that bilateral trade treaties were 4 or 5 pages long. It used to be they were relatively short, right? It used to be that actually you wouldn't have to be a lawyer, a politician could read it and understand it. That's not the case anymore, right? And that says something not just about the kind of complexities of the process, but it also, I think, says something about that discussion about amicus curiae that we were having in the other session about how people can represent themselves within that process, even if they were allowed into the process. And we had cases also in terms of that democratic process being undermined, cases of chilling, as Nick Dearden called it. So what happens when there is a case in front of an arbitration panel, it means that other countries stand back and wait for that decision, or even discipline themselves, right? That's the process of chilling that he gave an example. The example of New Zealand actually does happen. We have very, very clearly from John Hillary, actually from his discussions with the European Commission, that they don't take their mandate from the European people. Now, without getting into the kind of constitutional complexities of that, the question John's posing is, what does that mean if TTIP indeed goes through, right? Never mind if it goes through or if it doesn't. The question remains: where is the Commission taking this direction from here? And the question that Paul raises, of course, the hearings. And back to the ISDS hearings, if they were in public and if there was a right to appeal and so on, would that make any difference? I think that's an open question, right? Obviously, people in this room are demanding more transparency and more openness. If there was more transparency and more openness, would it just be more transparency and openness around a process that they don't have access to anyway? I don't know, or would it improve access? I think that's an open question. And there are questions, I think, about much broader questions about how we approach this. And look, if we were sitting, I don't think the room was full. I think Nikos maybe thought the room was full of 1970s socialists and communists. Maybe there are some. I might be one of them. But I actually don't think it is. But if it was, I mean, it's a serious point. If it was, we'd probably be talking about a choice between reform or revolution, right? And clearly that's a ridiculous choice. It's not a choice. But I think there was a tendency in our discussions to kind of go down that road, and I do think it raises serious questions, because do we want reform of this process, or do we want this process not to go ahead? And that becomes really crystallised in the discussion about the NHS. So Karina very clearly talked about how we know the 49% patient ceiling could be. She said she didn't know if it would be, but it potentially could be breached or lifted by TTIP. But ultimately, the discussion was, okay, well, would the ISDS or an explicit ring fencing of or carving out of the NHS from the treaty would be an important thing. I think everyone agrees with that. But of course, Keith made the point that doesn't necessarily exempt the NHS from some of the other procedures. I actually think Karina's point around this really makes us think about what we need to think about beyond TTIP, where she says, look, if we had a genuinely public NHS system, we wouldn't even be talking about this, right? Because there wouldn't be a prospect for entry. That's another question. But will the NHS carve out make any difference? I think that's one set of questions that people were really concerned with asking in terms of this. Sorry, I'm going to be clumsy, reform revolution. I'm going to be 1970s about it. And the second one, is removing ISDS enough? I mean, I think that was a genuine kind of debate that people were having, because as Gabriel said, and I think Gabriel was the only person to in any detail discuss the regulatory convergence and regulatory cooperation aspects of TTIP, which of course, regardless of the dispute resolution system, impose various mechanisms to create a so-called level playing field in regulation, which, as some have argued, would ultimately be a race to the bottom, and probably Europe would be forced to drive down standards on particular things. So, and of course there's a regulatory cooperation chapter in TTIP that we haven't really discussed, that really drives a lot of this, and actually the question about whether ISDS is enough really can only be discussed in the context of that attempt to harmonise regulation, I think fairly brutally if you look at some of the provisions of Regulatory Cooperation Council, which will make key decisions about whether we have to breathe in particular chemicals. Sorry, I'm using evocative, but that's essentially what, from my perspective, would be happening. So I think those two questions crystallise a set of issues that we only really got into discuss. I'm really sorry if I haven't. I meant to mention everyone. I'm really sorry if I haven't mentioned everyone. But I just want to say that this is one of the best conferences I've been at in terms of really going into a subject of crucial public importance in detail, drilling into it and really actually opening up questions. And I suppose that's where I would leave it. And particularly the question that I know that we need to open up, given the strength of feeling and the fact that we have people who've been involved for a long time in campaigns, activists for governments and corporations, and activists against governments and corporations, and some activists are making the case for small companies. What do we do, and where do we go from there, and how is it we can engage with this? Because clearly, if there's one thing that comes out of today, we have a profoundly undemocratic process, and the reason that we're in this room talking about it partly is because we're never going to get to talk about it in a room where the decisions are actually made. So maybe that's a question.
Okay, we are very pressed with time, so I'm just going to say two things because you just mentioned the regulatory cooperation chapter, and what is highly problematic for me about the regulatory cooperation chapter is that it changes the order of European norms and values. Now, Paul said that he's obviously not very happy how the European Union is structured at the moment, and we can all agree with that. But if you look into the, and this is something also which really makes me uncomfortable as a lawyer, if you look into the Treaty of the European Union, it doesn't only talk about economic efficiency, it talks about a lot of other things like sustainable development, like competitive market economy, and so on and so forth. If you look into the regulatory cooperation chapter, it puts economic efficiency above and on top of all the other European values. And the second thing is, this is very, very important, I find, about democracy, and this is by no means exclusive to TTIP. One of the things which I really miss is the increasingly, the discourse of policymaking, which is becoming increasingly technical by the creeping of not only legal but economics terms which are not accessible to the public and which are sold to public as if they are positive science terms. Efficiency is not a positive science term. How it is calculated is not a positive science method. These are all open to question. And because of this increasingly technicalized way of policymaking, even we had full access to the policymaking process of the TTIP, we would have very little chance to make an effect on that as individual citizens, because the discourse of it is not open and accessible to us. And I don't think this is by any means an accident. This is a process which has been promoted by the so-called experts for many, many years. And this is also, it sounds very subtle, but the discourse of policymaking is also something, not only in the context of TTIP, but in the context of all economic policies in particular, that we should talk about very seriously. Thank you very much.
Okay, I guess we're supposed to be moderating something ourselves, so I'll try and moderate myself and be quite quick. It's just I'll use moderate language. I'm definitely using moderate language when it comes to human rights law. So I'm a human rights lawyer, ostensibly one who doesn't really believe in the power of human rights law. So my point goes to that theme, and I think Dave's I'll borrow his reform and resistance point. So I was wondering today throughout the conference, it's one of the first I've been at for a long time where human rights law has actually been on the back seat as a sort of language of resistance, or a language of articulating how do we think about this problem, this global problem. With the exception, of course, of Bernali, I keep pronouncing your name incorrectly, Bernali's excellent talk, which demonstrated to us that human rights law is relevant. So my question, I suppose, is, and I'm going to speak as somebody who does believe we need reform or resistance, probably resistance to TTIP, and I wonder to what extent is human rights law a language that can provide that vehicle. And I have some skepticism about that, and I was pleased to hear languages other than human rights law that are available, particularly in Paul's talk and in Keith Ewing's talk about workers' rights, that there are other available languages, and I wonder whether we should be using those more. From the very simple perspective that when we look at rights in the TTIP negotiations, they're used rhetorically on both sides. Rhetorically, free trade has always been about, according to those driving free trade, promoting rights and freedoms. On the other hand, we're using rights language to argue for resistance of free trade. So how does this work in practice in negotiating agreements? In the negotiation agreements, the Human Rights Council and bureaucratic human rights organisations constantly talk about the need to include human rights provisions. And yet, if we just read from business, human rights and business guidelines, I think many in this room will find this relatively laughable. States must ensure that trade and investment agreements do not constrain their ability to meet their human rights obligations. That's how human rights law articulates the demands to sort of protect human rights law. So is that a strong negotiating tool? Human rights law, can it stand up against the sort of investment treaties that we're looking at? On the other hand, when it comes to resisting these from a grassroots perspective, is rights a good language for that, given that it is an individualistic language which we normally use against the state, and in this discussion the state is almost on the back foot, where the state is we have at least portrayed it as on the back foot against corporations. So to what value is human rights law? That's my question for you. I'm not throwing out the baby with the bathwater. We talked about Ireland earlier, and certainly the resistance to the privatisation of water in Ireland was articulated in rights terms. So I'm opening it to the floor. Can we use the language of human rights law valuably in reform and resistance?
Have you got any time left for so 4 for 2? So then
8 minutes.
yes, we've got 8 minutes for questions, and then yes, Gabriel.
Yeah. So what I would say is excellent. Thank you very much for a great summary. I guess I wanted to reflect on the theme you pulled out at the end, in which Firat and Michelle alluded to, which is this idea of reform or revolution. And in a sense, for me, it has to be a bit of both. So, on one hand, I think it's key that there's a fight against the TTIP as it's currently existing, the TTIP of cutting red tape. But on the other hand, actually, if that's all it amounts to, and if the sort of campaign fizzles out, and I don't mean this as an offence against those people who campaigned for many years against trade agreements, but if it fizzles out much like the anti-globalization campaign did after the defeat of the Mai and the stagnation of the Doha round, then you're still left with all the iniquities of the global trading system. So what myself and my co-author argued in the book is that this is the moment really to seize the seize the day, and sort of think about possibly coming up with a good TTIP. Which is not to say that maybe it should probably not be called TTIP, but I think actually there's some ways in which it can be harnessed in positive. So if it is about reinforcing the positive things we have in the European project, precautionary principle, if it's about harmonizing standards upwards like you have in the single market, then that could make that, then TTIP could, or another trade and investment agreement could make a positive contribution. Now, I'm not saying this is likely or the most likely option at this stage. But I think it was completely unthinkable a few years ago, and so that's the direction we have to push it. If you look at, for example, the Commission's negotiating text on regulatory cooperation, you see now some of these objectives being mentioned in a way that they weren't before, right? So there's a mention of the precautionary principle in the text, in a footnote. So I'm not saying this is it's in any way satisfactory, and all the points I was making in my presentation still hold. But what I'm suggesting is that in some ways the pushback has had an effect that's positive. So I think there has to be a certain endurance to the struggle, and I think there are possibilities to reframe things, and I think that's, I'm not saying it's the most likely option, but I think these are avenues that are worth considering.
Yes.
You talked about the rights of the investor and the rights of the state. The consumer rights have not been mentioned because we don't have any rights in all of this. But is there any consumer law that can be used? Is there any EU consumer law that can be used? I mean, the consumers, after all, are paying for all of this. They're paying for the state, and we're also paying for the companies themselves. So why are the consumers being left out of it completely?
This is, I mean, I'm not saying it's a question to Michelle, but it's getting to the heart. It's getting to the heart of what you're talking about. You know. So, for example, I think to extend your question, would the European Court of Human Rights be useful in challenging some of the impacts of TTIP in the future to protect consumers' rights?
Yeah, well, there is an impact on consumers, and I don't think many consumers are aware of them. I think this is why there's a lot of apathy amongst the public, because it's not being made clear.
I think Maluda's got an answer for you.
I can comment on this. It's by way of response is that, yes, there are ways of incorporating, first of all, the TTIP, and one of the most neglected aspects of it, which is regulatory cooperation, will have enormous implications for consumers, because that's where regulatory standards are going to be discussed. And so far the European Commission's promise has been that there will be no reducing of existing standards. But that's where, again, more civic engagement and more scrutiny from civil society would probably push the Commission to do more than it was initially prepared to. And the same thing actually happened with the rest of the TTIP. What that he has done, despite being a fairly evil thing, what it did, it brought to the forefront of public attention all of these important issues, because prior to TTIP, only a handful of people knew about ISDS, and now people like yourself do know. And it actually pushed the Commission to do things, to launch reform, and maybe those reforms will cascade down and somehow, I don't know, influence the people in the global south, because this is another thing that is remaining kind of out of this entire picture. So, but going back to consumers, yes, it is there. It's all about regulatory cooperation, and as Rob House mentioned this morning, that is the danger of us focusing only on ISDS, and trade lawyers know that very well, and they're actually very happy that regulatory cooperation is not receiving as much attention at all, and if it did receive at least half of the attention that now belongs to ISDS, then probably again we as a society could have had some input into how norms are being developed there.
I think there was civil society push, or civil society opposition in the context of certain issues which are quite like buzzwords, or the evil scenarios which emerges in the public's mind, like chloride washed chicken imported to the EU, or hormone beef pesticides and so on. So what the Commission does is they say we will never compromise these food safety or consumer standards. And this is like an upfront statement also if you go to their website and go to the TTIP negotiations bit where they explain everything. But what they don't do, and which kind of raises legitimate concerns, is that they don't actually reveal the negotiating documents, the demands of the US, their negotiating mandate, and look, this is how actually we are not compromising it at the moment.
Can I make a very short point? Because I actually think the issue around workers, of course, but consumers particularly, can really galvanise public opinion here, and also the gendered aspects of this, right? Because I mean, anyone who kind of studies the effects of chemicals on human health knows that there's a gender discussion, and one example in terms of this regulatory cooperation. Sorry, can I just get to the point? Of 1,200 chemicals that the EU bans for use in cosmetics, the US only bans 12 of them. So one of the fears is that TTIP will force women to use cosmetics that involve chemicals that they didn't before. And I think that's the kind of discussion that can really galvanise people and make it real in the way that you're saying. Whether it can be challenged, that's another.
Also, like we didn't have time to discuss one of the issues which are very close to my heart is the animal rights and products tested on animals. Obviously, the standards of the EU and the US are very different. There's again a risk that our standards are harmonized using the US standards as benchmark and animals suffering as a result of that. There's a question that...
I'd just like to say thank you to everyone who's been here and been on the table. But there's one thing that's going to be left out. We don't want to be left in limbo now. That's it. We want more information of where to pick certain ideas up and develop them. Our knowledge has been expanded tremendously today. We want to pursue that further.
Okay, that's great. Actually, one of the things that we were discussing during the lunch breaks, that what we are going to take home, all of us, or what we want to take home individually is, okay, we learn all this, but what we can do against TTIP, especially at the local level. So this will be our next process of thinking. So thank you very much, everyone, for the excellent discussion.